Hello, everybody. So hopefully you can see my screen, and I hate doing this, but I'm actually going to be going through all these questions again, only the first page though. So first and foremost, we're going to say, what is an example of personal property? We have household furnishing, gas range, built-in dishwasher, or disposal. We said simple, right? Household furnishing, right? Hey, awesome. Number two, market value is most closely related to, that is the selling price. We have replacement price and reproduction price on there. I actually wanted to point out what those two were. You have replacement price is actually when you are replacing everything, okay, like for like, when it's exactly 1-to-1. Reproduction price is when you're actually reproducing said structure, said item with something that might be similar to it, but the exact thing might not readily be available. And those are most closely related to cost approach of appraisals and analysis. That's just really nothing. So purchase money mortgage is A, the seller takes back the mortgage as part of the purchase price. Okay, so C and D are not the correct answers because there are no prepayment penalties in the state of New Jersey. So what happens is it would either be A or B, and A is the correct one in it. Number 4, if Jane Smith owns a property, fee simple, she can do all the following except, that's a key word, condemn it. Condemnation is a process strictly reserved for eminent domain. And now, the responsibilities of the Real Estate Commission include none of the above. The New Jersey Real Estate Commission does not set fees for licensing exams, promulgate real estate laws, nor do they set license fees. They're a public advocacy group that governs the interactions between licensees or people who are misrepresenting themselves in real estate transaction as a licensee and the general public. All the following owes a fiduciary responsibility owes a fiduciary obligation except, okay, mortgagor, which is the buyer in a transaction, because when you owe a fiduciary responsibility, that's when you are the agent and there is a principal involved. So 7, broker terminates employment of a salesperson, he or she must immediately return the salesperson's license to the Real Estate Commission. Some people answered return the license within 10 days. Actually, in the state of New Jersey, you have to be paid by your real estate broker for closed transactions within 10 days. 8, an abstract of title is a brief digest of title to a particular property. So it is a brief digest of the entire title to a property. It's not each deed, because that's sort of irrelevant. It's not an appraisal of the lands, and it's not a summary of all the improvements or encroachments. That's something that you would find on a survey more than anything else. And now we're officially where we left off on my first video, but now we're at the real thing. So now the rest of the class is probably going to participate. So number 9, an offer may be terminated by lapse of agreed period of time, acceptance of offer, counter offer, or all of the above.
D. A.
C. Hey, let's try D. D, all the above.
Yeah. So if you accept an offer, how can you terminate the offer?
An offer may be terminated. It's not that you're terminating the offer. Accepting the offer turns it into a bilateral contract. So it's no longer an offer. A counteroffer turns it into a counteroffer, right? A lapsed agreed period of time, if a buyer is putting an offer on a property and says you have till 7 p.m. to accept this, and that passes, that would also be a way that the offer will no longer be there. Who is required to comply with state licensing laws? An individual employed to handle sale of units in a condominium building, one who for compensation affects an exchange of real estate, one who auctions real estate, or D, all the above. Yeah, all the above, right? Because anyone who accepts good or valuable compensation, right? Good or valuable compensation. A clause in an agreement of sale providing that the buyer has inspected the business, takes goods, fixtures, and other property as is, protects the seller completely in the future, will not protect the seller against clear showing of fraudulent misrepresentation, is required under the Bulk Transfer Act, or D is the protection of the vendee. B, yeah, if there's a clear showing of fraudulent misrepresentation, selling a property as is will not protect the seller.
Like, what's an example of a clear showing of fraudulent? Like, you knowingly concealed anything?
So I think that in the example that I gave you with the elevator and the death that was caused by the elevator, where it was not disclosed, right? And the elevator not functioning properly was something that we talked about, was an issue with the home. That's something that should have been disclosed. So they could have bought the property as is. Let's assume that in that transaction they bought the property as is. That doesn't clearly, the seller was trying to misrepresent the property as not having that issue, not having the stigma. The stigma wasn't what you needed to disclose. It was that the elevator malfunctioned, caused the death. And since then you have replaced it, repaired it, or done whatever, but there was a malfunction that occurred that needed to be disclosed. So, if a licensee is convicted of forgery, the Real Estate Commission in New Jersey will not grant a license within D, 5 years. That's the answer. Acknowledgement is given by an attorney at law, the party signing the instrument, notary public, or the registrar of deeds. Registrar of deeds. What is this? So the acknowledgement is actually the party signing the instrument. Yep. A notary public is notarizing it. Notarizing it and acknowledging it are two different things, right? An apartment manager receives 30% of the first month's rent and 6% of each month's rent thereafter. If the rent is $320 per month, will his annual fee amount to? A, $211. I think it's B, $307.20. I'm not going to do all the math there, but that was a pretty straightforward one. If you just work through that one's pretty easy. But
So what is it? B?
B as in boy. 15. An option is a unilateral contract binding only to one party, accepted by performance, or D, all the above. D, all the above. It is a unilateral contract. A unilateral contract is described as binding only to one party and accepted by performance. So literally, you can go through all those things, and that literally is what an option is. So it would be D, all the above. Which of the following properties would not qualify for a 1031 exchange? An office condominium, a vacation home rented out for the month of August and occupied by the owner in the month of September, C, a business property, D, an investment property.
B is very specific.
B is extremely specific, and that is the answer. It's and it's not the answer because it's specific, but in a 1031 exchange, it's for investment properties. Okay, it's for investment properties, and they have to be like and kind. What happens is it's a way of sheltering tax dollars from capital gains. Okay, so what happens is, just to kind of go through it a little bit, just give you the 10,000 foot view of a 1031 exchange. If I have a condominium, okay, let's just use that as an example, and I want to sell that property and then buy another condominium, what happens is the government allows me to not have to pay capital gains taxes on it, just to reinvest it into the real estate market. What the government does is they allow me to use a third party. There is a set time frame as far as how long you have to identify that property. There's a window of time. You can't just let the third party hold it and say to them, oh yeah, I'm going to find a property 3 years from now, and just have that money sitting there. You have a certain amount of time that you have to go back into a like in kind property. Okay, something similar. All right.
But
So
how does
vacation home
now-
wouldn't work.
Oh, okay.
Yeah, the vacation home, because that's not an investment property because you live in it. It is part of your residence. So second homes don't work. Like if you're a snowbird, it doesn't work. Your client plans to get divorced shortly before closing of a property. She and her boyfriend just purchased and asks you about how to hold title to the property. You are probably sitting there trying to figure out what this person is doing. You're probably thinking you're trying to figure out, is she getting divorced? Her boyfriend, like how many men are in her life right now? So that was probably where you're thinking with the question. And she comes to you and says, how should we hold title to the property? Do you say, hey, get divorced first? B, conceal the pending divorce? C, consult an attorney? Or D, choose joint tenancy? C, consult an attorney. So that question just could have been super convoluted. It doesn't matter because the multiply by 0 answer is always, if it's that complicated, and one of the answers is consult an attorney, that's the multiply by 0 answer. Yeah, absolutely, consult an attorney. Of the following, whose interest is benefited by an acceleration clause in a mortgage note? The borrower? The lender? Yeah. The lender. What is the acceleration clause on the mortgage note?
All the money is due immediately
Because of what?
because you defaulted on the loan.
Bingo. So because of default, it's saying, hey, the full amount is due, and that's to protect the lender, right? After paying a broker's commission of 7% and expenses of $317, a seller desires a net amount to himself of $34,000. What will the sales price have to be? The answer is A, $36,900. Let's keep moving. The right by which a creditor has a claim against the borrower's property is most broadly described as a lien. Absolutely. Not a judgment, not an attachment, not a right of execution, but a lien. When there is a first violation of the Licensing Act, the Real Estate Commission is empowered to impose monetary fines, revoke the license, suspend the license, or D, all of the above. D, all the above. Yep, they could do all those things. Let's keep rocking and rolling. We're on 22. Making good time, too. Which of the following is an essential element of any contract? A written instrument, words of conveyance, acknowledgement, or consideration? C. So what are the legal requirements for a contract? What do we need for a contract?
Offer and acceptance,
We need to offer an acceptance, right?
consideration,
Consideration, right? That's why C is the answer. Competent parties, right?
yeah.
Right? Wait. There's something else we need for a valid contract. Can I have a contract? Yes, thank you. I was going to say, can I have a contract to murder someone? No, I cannot because it has to be legal. Legality of the object. We need to have competent parties. We need to have consideration and offer and acceptance, right? So you don't need it to be written. There doesn't need to be words of conveyance, and there doesn't need to be acknowledgement. As long as there's offer and acceptance, that works as all of those things. Okay. Environmental Protection Agency, EPA, was created to, I'm sure the government guy would get this right. Yeah. They enforce federal environmental laws, right? Because they're a federal agency. Yep, there we go. Real estate values are most affected by, please get this right. Location, availability, money, appraisal, or national trends. Location. If I have a shack in the woods in Vermont, and I take that same exact shack and I put it on the beach in Belmar, is there a different price for it? Absolutely. Shack in different places makes a whole heck of a lot of difference. Location. 25. Any person, partnership, association, or corporation who authorizes or employs another called the agent to perform certain acts on his or her behalf is the, I actually said this before, principal, right? There's an agent and a principal. That's how we have our agency relationships. We have it as an agent who owes the principal fiduciary responsibilities. What are the fiduciary responsibilities?
Care.
Sure.
Obedience,
Yeah.
accounting,
Accounting,
loyalty,
loyalty,
and disclosure.
care, obedience, accounting, loyalty, and disclosure. Absolutely. Boom, boom, boom. Actual notice is notice has been received by direct communication, either oral or written. The same as constructive notice, recorded notice, implied notice.
A.
Yeah, it's actual notice is saying, hey, you've had notice, like we've told you, either oral or written. Real estate salesperson may lawfully accept a bonus for the completion of a difficult sale. This is another multiplied by zero
Only
answer.
from his or her employing broker.
Only from his or her broker. It doesn't matter that it was difficult. Doesn't matter what it is. You can only be paid by your broker. You can only be paid by your broker. That's it. A salesperson has listed a house for sale and has knowledge of a latent defect in the building. His responsibility is to ignore it, disclose it. Yeah. Disclose it, right? There's also other ones. Report it to the building department. No. Correct the condition.
The buyer doesn't, I forgot the term, the paper that you have to fill out, like the disclosure, seller's disclosure.
Sure.
What if the buyer doesn't write it and just verbally sort of says it to the salesperson? When they're filling out
Great
the
question.
paperwork, they have to add that in there.
Well, what happens is this: it has to be disclosed. Okay. If a salesperson is aware of a latent defect, and this came up actually the other day, where it was suspected that there was asbestos in a condominium that I was selling, and the salesperson, the listing agent, sold about 45 units in that condominium complex. She said to us, if I have knowledge of the fact that there is asbestos in this building, I must disclose it. And out of all the units I have sold, there has never been someone who has suspected it and found asbestos. So the likelihood, and she even said, if there is asbestos, I am unaware of it. But if you do find asbestos, then I must start disclosing that to everyone else.
Yeah.
So what happens is, it doesn't matter how that information was received, okay? Because I'm sure that even in the question going back, where we were talking about the latent defect of the whatchamacallit, of the malfunctioning elevator that caused the death of the two young children. What happens is the elevator malfunctioning, whether that was told, that was more than likely, if I had to guess, that was more than likely orally told. I don't think someone wrote something down or emailed it to anyone. However, everyone knew about it and everyone had knowledge that it was known. So latent defects need to be disclosed regardless of how that communication is given, because if we're going back to actual notice of like defects, if it's given to you either orally or written, right? And someone can prove this, then it is. And also how they proved it was the listing agent was the daughter, I believe, of the seller. So like they had not, it was like one of those things that they didn't not know. Like no one could go into a courtroom and go, I had no idea. They knew. So let's go to 29. Pertaining to the salesperson's license, which of the following is true?
It must be prominently displayed in the branch office where the salesperson is employed.
This is a little bit of an archaic thing. The Real Estate Commission does not do this anymore. That's why I'm moving this test to a practice exam. But here's the thing. What's good to know about this is this. There are going to be several practice test questions on your test that are going to allow for you to have like some leeway where you're not going to be scored on them. So this would be one of them that you wouldn't be scored on, in my opinion, because it's an inaccurate question. However,
So that used to be the case and it's not anymore.
yeah, because everything's electronic now. But when it wasn't electronic, when this test was written back in 2014, that was what happened. They framed all the licenses and they put them in the main office. So that's what happened back in the day, but doesn't happen now. Full and complete ownership of land, as recognized today, exists most nearly in full and complete ownership.
Be simple.
Fee simple. Yep. A life estate is ownership based on the life of someone or something. An estate in remainder would have to do with having a life estate or something like that. An estate in reversion would be similar to that, where you do not have full and complete ownership. All of those things, except for C, is something that has a restrictive ownership on it, right? A newly licensed broker can maintain an office in all but one of the following.
The home of a salesperson and his or her employee.
Right. It could be in his or her residence as long as it's zoned for commercial use. Okay, so it has to be zoned mixed usage. So, like, I can't just go to my house and say, Steve's awesome, amazing real estate company, read all about it, you know? And I can't do that. I can't just have my little house as my real estate office and say, yeah, I'm going to work out of that. Okay, in the state of New Jersey, that cannot be. And it also cannot be in the home of a salesperson that you employ. It has to be his or her residence is zoned for that use. A commercial building or marina would be somewhere you can have it, you know, because as long as it's zoned for commercial, you're fine. Recording a deed gives the greatest benefit of the OR gives, EE receives. The one receiving the deed, the best thing is for them to record that deed, correct? So it's D. 33. When a buyer and seller enter into a definite purchase agreement, except that no closing date is specified, the contract is A, void for vagueness, B, voidable, C, enforceable, D, not acceptable.
Enforceable.
Enforceable? Do we have any other enforceables?
Avoidable.
I have avoidable or void for vagueness. Are you trying to wrestle with those two?
Yeah.
Okay, so here's what you have to do. If you're going to tell me that it's voidable or void for vagueness, tell me what part of the contract is either missing or inaccurate. Go through what we just went through as the four components
Closing
of.
date is not specified.
Okay, so where does it say in our components of a contract that you have to have a closing date? You don't need to have a closing date, right? So this is totally enforceable. Let's see. Yeah. Closing date is not something that is required for a contract. Deeds may be prepared by any licensed real estate broker, an attorney, or the owner of the property being conveyed, any knowledgeable person, or D, an attorney, in fact, under the authority from the grantee. So you're telling me that the owner of the property can't write their own deed?
No.
They certainly can.
So B.
It's B. If you're on your deathbed and you want to transfer your property, you can write a deed. As long as it has the legal components of a deed, right? Right? Meets the legal requirements of a deed. You know, like if you Googled it, like if I'm on my deathbed, right? And I hit all the major components of a deed. Let's say I had the lot and block number of my property, right? And which is legal description, right? We had offer and acceptance. We had consideration, let's say for love and affection, right? So let's say I'm on my deathbed. Oh, kill me off, okay? And I wanted my precious beach house to go to my dog. I had to go to my dog. So it's going to Rosie. As long as I meet the requirements of a deed, legal description, offer and acceptance, consideration, right? And what else do we need? Legal description, offer and
Legality
acceptance. No, you're trying to think of contracts. Jeez, it's all melting into one. Legal description, consideration, Okay, offer and acceptance, and there's one more component.
Offer and acceptance are both, no?
Offer and acceptance, and we need the signature of the grantor.
Can
Right?
you say them again?
Sure.
Right.
Legal description of the property. We need consideration, offer and acceptance, signature of the grantor.
But two of them are the same, right?
No.
Without legal description? Oh, no, just the consideration. No, offer and acceptance and consideration are both the same.
Nope. Offer and acceptance. Would you like this pack of gum? Yes, I would.
They're the same as the other.
How do you give it
They're
to a
the same
dog?
as.
You can.
Yeah.
Someone or something. Like there's people who've transferred properties to dogs before. Let's not digress there. When money is deposited in a client trust account,
They're the same as a contract. Offer and acceptance and consideration.
yes, those are the same as a contract. Yeah, so those two cross over. So when money is deposited in a client trust account, the deposit money must be promptly returned to the buyer if the offer is not accepted. 36, fiduciary responsibility refers to fiduciary responsibility relationship refers to the relationship between two brokers, the relationship created between plaintiff and defendant, the position of trust between broker and his or her principal, or D, none of the above. How about C? Fiduciary relationship refers to the position of trust between the broker and his or her principal. What is a principal?
Yeah, the client.
Darn. So what happens is they, instead of using the word agent and
Yeah.
principal, right? They use what, wonky words? That's why you have to read the questions twice. You got to do it.
It's the representative of the broker.
Right. In the consumer information statement, we understand that the agency relationships are actually between the broker and the principal, right?
Just carrying it
Hence,
out.
right. Bingo, bango. Generally, a contract between a competent adult and a minor is voidable at the option of the minor, voidable at the option of the adult, voidable at the option of either party, or enforceable.
Enforceable. How could that?
Yeah, enforceable.
Well, you're thinking of an implied contract, right? And again, we're talking generally, okay? So you gave me a specific there. This is broad strokes of everything. Generally, a contract between a competent adult and a minor is going to be viewed as voidable at the option of the minor, okay? Because here's the thing, it might meet all the things. It might be, totally acceptable, but there is a chance that someone will come in and say, hey, that kid wasn't thinking straight. Like, think of it as if you had a 16-year-old son or a 15-year-old daughter, or whatever the case may be.
C was
it's-
the answer to 36.
36 was C.
Okay.
Yeah, I heard
You feel the roof
that.
down?
Yeah, we're definitely we have some thunderstorms here while we're recording this. So generally, a contract between an adult and a minor is voidable at the option of the minor. 38, to be licensed as a broker, you must be legal age, citizen of the United States, a resident of New Jersey, all the above.
All the above.
So you need to be a citizen to be a broker?
Oh, I'm sorry.
Resident,
Yeah, you only need to be a resident.
right?
What if I lived in New York?
So then the answer is of legal age.
Yeah,
A. Do you need to be a citizen of the United States to be a broker?
No.
No, you need to be a resident. Do you need to be a resident of New Jersey to be a broker?
No.
You just need to sign what?
The agreement to be sued.
The agreement to be sued in New Jersey, which is referred to as, because we're going to use our fancy words. We're fancy word users.
list pendants?
List pendants is legal action pending. Nice
Is that
try.
really? Oh.
Yeah, no. You see, this is why we have to. What's funny is this, and that's why I always tell you guys, you have all the information in there. You just need to file it under the right thing. Like that's why it's like people are like throwing things out there. So the fancy pants words that we're talking about, which is what is needed if you are a resident of another state and you're looking to be licensed in New Jersey, you need to sign an irrevocable consent to be sued. Okay, irrevocable consent to be sued. A 4-bedroom house with 1 bath is an example of economic obsolescence, physical deterioration, functional obsolescence, or all the above. Obsolescence.
So this one.
I think
What is it?
Functional
I've
obsolescence.
never heard of obsolescence.
Like obsolete.
obsolete.
Yep.
No, I know the word, but not in these terms.
No, it's not usually written like that. So.
Yeah.
Yeah. So what
Is it
happens is there's several different types of obsolescence, which is basically the present status of its B. Looking at my computer. Okay. It's B. If you wanted to look at my computer, you could have sat right next to me. So there's several. Well, good for challenging you, but here's what I'm going to tell you. So obsolescence is this basically the status of being obsolete, right? There's economic being obsolete, right? There's functional being obsolete, physical deterioration. There's also external obsolescence as well. External obsolescence will be something like they start building a dump, a landfill in your town. That's some sort of external obsolescence, right?
But why is a 4-bedroom house with 1 bath obsolete though?
Because it's not as functional.
It's not
It's not as functional as it used to, because what happens is the way that we live nowadays in comparison to, homes that were built in the 70s, in the 60s, right? There was one income household. The husband went to work, right? And the wife was a stay-at-home housewife, right? So what happened was the only person that would need to get ready in the morning would be gentleman going out to work, and children getting out to school. He would probably be leaving earlier than them. So what happened was a 1 bathroom was sufficient. Now we're talking 2019. We're in dual income households where there are 2 people trying to get ready at the same time. Plus, well, it's again.
Well, you could rule out economic or
And physical deterioration, and you could rule out all the above. Look, we're going to keep moving and grooving because otherwise we're going to be here all night. Okay, earnest money may be held in escrow, but by all but one of the following: a real estate broker, an attorney, an escrow agent, or a real estate salesperson. D. Real estate salesperson. Thank you very much. A listing agreement provided for a commission to the broker of 6% for the first 30,000 and 3% anything above 30,000. The commission the commission received by the broker is $2,070. What did the property sell for? A. You can actually work a problem like that backwards as well, and just work each one of them and hope that it's A. But then what would happen is you would get all nervous if you worked it backwards, because if you got the first one, if it was A, then you'd be like, well, wait, let me see if B is it too, or let me see. You try to make sure that was the right one. Take you a little longer, but you do have a lot of time on the test. Which of the following is not a necessary element in the formation of a contract? Yes. D. I was going to say, we've said this so many times right now that this should be easy like Parcheesi when it's greasy. Ready? An agent is considered to have earned his commission only if the title is transferred, if he or she secures an offer from a prospective buyer, if he or she produces a ready, willing, able buyer on the principal's terms, or D, when the principal signs a contract to sale.
D.
Does he receive the title insurance in the mail like at a later date?
Yeah, that's totally different. Let's focus on this one. When does it say that they earn their commission? It is said they've earned their commission when they produce a ready, willing, able buyer on the principal's terms.
If the sale doesn't go through.
It's strictly saying, so if the sale doesn't go through, great question. The agent can sue if they have produced a ready, willing, and able buyer on the principal's terms. They can sue for their commission. Do they?
So I think the confusion with that question is the word earn versus the word deserve.
Or receive.
Okay.
They deserve their money owed, but are they earning it rightfully?
Don't confuse it too much. You ready? The question is specifically saying, when has an agent earned their commission? So when are they owed that money? Like, what is the trigger?
That makes sense.
What is the triggering thing? Like, what is it said that when you could say, I earned my commission on this, and you could legally then sue and pursue, litigation for it? That is C, when he or she produces a ready, willing, able buyer on the principal's terms.
Okay.
Unless otherwise agreed to in writing, the employing broker must pay all commissions due a salesperson within how many days of receipt by the broker?
10.
10. We said this before. Let's keep moving on. A function of the FHA is to build housing, lend money, guarantee loans, or insure loans.
Insure.
Insure, right. We said the VA guarantees them, right? FHA insures loans. That's a big thing. VA guarantees, FHA insures. Okay. And think of it this way. We provide for the veterans, the Veterans Association, the VA, they provide for the veterans and they put that guarantee there. They are guaranteeing that money. They are guaranteeing that, okay? The FHA is simply insuring the loans, okay? If after you purchase a property, you have survey made and find that your neighbor, through error, has built an ornamental fence 2 feet over on your land, this would be a basic example of an B, an encroachment. Yeah, absolutely. Encroachment. They're encroaching on your property with some sort of structure. The amount which a seller who does not have to sell will accept from a buyer who does not have to buy is called.
Value.
Ooh, what is this?
Ooh,
Confusing.
yeah. So let's talk about this. You ready? So let's mark out the two things. Let's mark out the two things that we know it's not, which is appraised value and assessed value, right? Because those would either require an appraisal or an assessment. So now what we're trying to deal with is this. Market value versus market price. When we're talking about value in the economics of examining a market, we are more than likely going to refer to it as value and not necessarily price, because price is definitive, okay? The market price of this is when I go to a good steakhouse, okay, they tell me the market price, okay? The market price is X. It's not, it doesn't move off of that. I mean, the market changes,
So it's
right?
almost like after a sale, you can deem something as a market price. But when it's for sale, you have a market value only because you really don't know how much a buyer is going to buy it for.
Right. It would be the amount to which a seller who does not have to sell will accept from a buyer who does not have to be is going to be closely related to market value. I like the way you put that. That was actually really good. And I'll leave it at that.
So it's A.
A. You're welcome. The recording of a deed guarantees title, ensures ownership, verified title, or constitutes constructive notice of ownership.
Transfer sale?
It constitutes constructive notice of ownership. The recording of the deed, right?
What does that mean? Constitutes constructive notice.
Great question. So what is a deed?
Transfer the document that transfers title.
Deed transfers title. What is title?
Proof of ownership.
Okay, so if I'm recording something, what am I doing when I record something? Like what? Why do we record things? I recorded my deed at town hall.
To prove.
How am I proving to and to who?
So there's another source of proof. Like if you're
You're
referring to
giving
town hall,
you're giving notice to
other
basically
people.
you're giving notice to the general public of your deed. You're making your deed known. It's considered constructive notice of ownership because you're saying, here's my deed, which transferred title. Title is proof of ownership, and here's my recording making it public. Does that make sense?
Yeah.
So that is how you basically give constructive notice for people to examine and be able to, see that you have title to the property because you have the deed, which transferred title, right? 49, known hidden defects in a property must be disclosed by seller only, broker only, salesperson only, or seller, broker, and salesperson.
I would say D.
Yeah.
D, I think we've pretty much established that, right? Seller, broker, or the salesperson all need to be able to disclose any type of hidden defects in the property. Right? 50. Which of the following factors have little or no effect on determining the value of a commercial property? Purpose of the appraisal income from the property, original cost of the property, or zoning.
C.
The original cost of the property has no bearing on the determination of value. Right? No bearing on the determination of value. The original cost has no bearing on that. Failure to perform or fulfill a contract is termed A, defect, fault, breach, or delinquency.
C.
C, breach. An agency agreement will be terminated by the death of the agent, the bankruptcy of the principal, the death of the principal, all the above.
All the above.
Yeah, if either one of them die, there ain't no agency relationship. Now, keep this in mind too. If there are contracts in place, okay, if there are contracts in place in regards to like a sale going through, the death does not, the agency agreement will be terminated. However, the contract in place could still be valid. So, depending on what they're asking about, if they're talking about the agency agreement, okay, and there is no contract attached with that in regards to the sale of the house, right? Then what happens is the agency agreement will be dissolved, right? If I have, so here's an agency agreement, I have power of attorney over my grandparents. If my grandparents pass away, okay, then guess what? There is no agency agreement there, right? But if during the course of me having power of attorney over them, I market their home for sale as a for sale by owner and I sell it, and then they die, the agency relationship is gone. However, that contract is still a valid contract. Does that make sense? Yeah. A lender charged 3 discount points on a $147,000 loan. What was the amount of the discount points? C, 4410. When listing and selling property, the real estate licensee should be concerned with which of the following environmental conditions? Presence of lead-based paint. Should they be concerned with USTs and mold?
It's not mandated. Right?
But here's, so you ready? You ready? Here's what they asked. Should they be concerned with them?
Yeah, I would
Yeah.
say all.
All of the above.
It doesn't say what do they require.
No.
Semantics count for something. Semantics suck. Logistics suck. But what should they be concerned with? They should be concerned with all of them. If the home was built before what date?
Something 1978.
1978, the presence of lead-based paint is required to be disclosed if there is knowledge and or reports. So they'll probably put down there. Most of the time, they'll say, have no knowledge, have no reports. Okay. When a person owns a property to the exclusion of others, he is said to own it in severalty, severed interest, right? Tenancy and severalty. After the completion of the real estate license preparation course, what period of time does the applicant have in which to pass the state examination?
1 year.
1 year? Is 1 year? Is 1 year. See you in a year if you keep failing it. Hopefully you do not. If you sell a lot for $40,000 after making a 17% profit, what was the original price paid? The answer is B, $34,188. A gift of land for some public use made by the owner and accepted for such use on behalf of the public, such as a street in a plotted subdivision, is called an
Dedication?
yeah. How about a dedication?
Never heard of dedication. But it
That's a
seems-
dedication.
Seems right.
It
It's
is
one
right.
of, it's one of the later chapters.
Oh, that's why.
Yeah, yeah, yes, yeah. The real estate licenses are renewed annually, biannually,
Every 2 years and odd
B.
numbers?
every 2 years, an odd number. So it will be B, biannually, July 1st, in the odd number years. Funds received for deposit in the guarantee fund may not exceed 150,000, may be used for the educational purposes of the Board of Realtors, may be used to settle commission disputes between licensees. D, are used to indemnify aggregated parties in real estate transactions.
D.
D, used to indemnify aggregated participants in real estate transaction that are not real estate licensees. This is for the general public, right? One of the following are not methods of which a contract can be discharged: divorce of either party, operation of law, agreement, performance, or breach.
Operation of law? I don't know. Is there law proceeding over contract?
There's
See,
plenty of laws. So if both parties say, nah, I don't want to go forward with this, they still have to.
A.
A, divorce of either party. Divorce does not mean, so let's say, yeah. Listen, you must read the questions twice. Not, except, all but. These things are going to throw you off because you're going to want to read the question how you read it, and you're going to go to the answers that you think are right. And what happens is it's the total opposite. Left is right, right is left. Okay? A junior mortgage is referred to as always a second mortgage, subordinate to the mortgages recorded ahead of it, a mortgage in which the interest rate is the subject of a periodic renegotiation period during its term, or a mortgage given to a minor. A subordinate to mortgages recorded ahead of it. That's all it is, a junior mortgage. A principal-agent relationship exists between a broker and his or her salesperson, salesperson and a client, broker and cooperating broker, broker and client. I know what they give you. I know what they give you on this one.
it's either B or D.
It's not B because the principal-agent relationship exists between, and I always know that I have A as the answer. I do not believe that to be right. I always say D. I say D on this one because it's a broker and the client is a principal-agent relationship, right? I mean that's it. You know, I don't care what I wrote down in here. It's wrong. It's D, broker and client, because the salesperson and client are not. Because again, remember, the salesperson is working as a representative of the broker. Right? Which of the following requires licensees to provide owners with a copy of the Attorney General's memorandum on the law against discrimination?
B.
Oh.
How about B? New Jersey rules and regulations of the rules and regulations of the New Jersey Real Estate Commission. Because remember, the New Jersey Real Estate Commission governs how we interact with the general public. So the rules and regulations of the New Jersey Real Estate Commission, literally, this is something. See, look, it says, which of the following requires licensees to provide to the general public a copy of the Attorney General's memorandum on the law against discrimination? Literally, that's like 101, what the Real Estate Commission is there for, right? Doesn't that make sense? Yeah. An area separating two incompatible zoning districts is called a buffer zone, median, divider, or setback.
Setback.
Buffer zone. Buffer zone. It's a zoning question. It's a zoning question. It's a silly zoning question. I don't really like it. I don't think you'll have something like that, but it's a zoning question. In advertising a listed property for sale, a broker may not legally run an ad in which they do not give the listing price of the property, state the kind of financing available, fail to state the street address of the property, or D, run an ad giving an impression that he or she is the owner of the property.
Okay.
B.
Whoa.
Choices.
Whoa. So what we say, who said B? Okay, that's wrong.
Okay.
Who said A?
If you address financing, you have to list everything.
I said if you did Regulation Z you're referring to, or Truth in Lending, right? Regulation Z strictly has to do with you talking about what type of, if you go into one specific detail, you must disclose all of them. This is strictly saying state the kind of financing available. So would you accept VA, FHA, cash, conventional? So that's fine. Run an ad in which you do not give the listing price of the property, totally fine. When there's when we have like celebrity clients, okay, believe it or not, something that we try not to do sometimes to protect, how much and things like that, we might not just generally throw it out there what the list price is. Like if I'm doing a mailer of some sort, I might not put the list price on there. That's totally fine. And state the address of the property. There's a lot of times where the address of the property is withheld. So the one that you cannot do legally is run an ad giving the impression that you are the owner of the property. Right? That's kind of like a scam. Which type of listing gives the broker the greatest protection? Exclusive right to sell, right? You have the exclusive right to sell the property. C. Zoning ordinances usually cover matters such as baseline, setback lines, deed restrictions, or prescriptions. Another zoning question, it would be setback lines. Setback lines basically are how far off the property, off the back of the property, you could actually build an improvement or put something on, right? 69, a contract for the sale of real estate is an executed agreement, an expected agreement, an executory agreement, or an aleatory agreement. This is a really
It can't be A because it's not executed if it's not.
I think that this question, bear with me, I think that this question is, I would accept either A or C. The correct answer is C. But I don't think that they really give you enough information in this question to really answer it the way that I wanted it answered.
Come to the conclusion that this is not finalized.
Right. Right. There's not enough information in there to know that it's not. So an executory agreement is where it's not finalized. And an executed contract. So a contract for the sale of real estate could be an executed agreement, but you don't know the state of the question of the agreement that they're questioning, right? With regard to the Real Estate Sales Full Disclosure Act, which of the following statements is not true? Cemetery lots are exempt from the law. The display of model homes is considered a form of advertising. Subdivisions, the recession period is 3 days. Subdivisions containing fewer than 100 lots are generally exempt from the act. The rescission period is how many days? How long do you have in the New Jersey Real Estate Sales Full Disclosure Act, Chapter 1? How many days do you have to cancel a contract? 7 calendar days, right? So the one that's not true is a rescission period is 3 days. It's actually 7 calendar days. Because if you remember anything about the Real Estate Sales Full Disclosure Act, I basically said to you, hey, this has to do with subdivisions and some out-of-state properties. They have to register. I told you 2 important things about it. They have to register with the Bureau of Subdivided Land Sales, number 1. Number 2, they have a 7 calendar day period to cancel the contract, right? Oh, 70. C is the answer. C. The Realtor Code of Ethics is a code put into law by the New Jersey Real Estate Commission, a code obligatory upon members of the National Association of Realtors, a part of an act pertaining to the prevention of discrimination in real property transactions, part of the statutes of New Jersey pertaining to licensed real estate salespersons and brokers. Which one is it? B. Unless you are a member of the National Association of Realtors, you do not have to be bound by their code of ethics. Okay, so if you do voluntarily join the trade organization of the National Association of Realtors, you are bound by the Realtor Code of Ethics. Which of the following are required to create an agency relationship? Written agreement, compensation by the principal, or consent of the principal and agent, or all the above?
D.
But I think
So you have to have a written agreement?
I would think so.
Watch this, watch this, watch this. What if buyer comes into my office? Okay.
Let's see.
Buyer comes into my office, right? You need consent. Like, buyer comes into my office, they say, hey, I want to go see some homes. I make sure I give them the consumer information statement up front. And then after that, I'm like, hey, let's go see some homes. Absolutely, we could do that. I am working for him. The intention of, I've laid out in the consumer information statement how I intend to work with them, right? Because the consumer information statement states how I can work with them in the state of New Jersey and how I intend to. 73, the purchase price of a home is $44,000. The down payment is 3%. Of the first 25,000, 5% of the balance. How much will the seller pay if she was charged 4 discount points? The answer is C, $1,692. A real estate deal is made between a seller and a buyer without the services of a broker. They arrange a licensed broker for a fee to prepare certain instruments. He or she may lawfully prepare the agreement of sale, the deed, the purchase money mortgage, or deed none of the above. So
Hey,
the answer, okay, as far as preparing certain instruments, they cannot act in the capacity of an attorney, so they cannot compare. They cannot charge a fee to prepare a pre-filled, cookie cutter boilerplate contract of sale. They're not an attorney. They cannot lawfully do any of these things. So it's D, none of the above. The method most frequently used to determine the value for a fire insurance policy is what? Sales, cost, income, or declining balance?
Cost.
Cost approach, right? Cost approach. They will use either reproduction or replacement value. We've already gone over what reproduction and replacement value are. When a broker prepares a document pertaining to a real estate transaction, he or she must give a copy to all parties signing it at the time that the signature is obtained. He or she must sign the document him or herself. He or she is violating the law. He or she should record the contract. How about A? He or she must give a copy to all parties once at the time the signature is obtained. Okay.
But don't they have to record record the contract too?
Why would I have to record it? We record things. We were just talking about this with deeds. We record things in town hall in order to give constructive notice. You don't have to give constructive notice of a real estate contract being signed, right? You don't have to record it. That's an unnecessary step. Right? A mortgage is released by reversion, reconveyance, discounting the loan, or satisfaction. Satisfaction. I can't get none. Bum, bum, bum. A broker owes an obligation to divide the commission with another broker chosen or preferred by the buyer. B, divulge the buyer the lowest possible price they will sell for. C, present to his or her principal all written offers he or she receives, including all terms and conditions of each offer signed by a prospective buyer. D, nobody. Correct answer is C. They must present all his or her principal with all written offers he or she receives, including all terms of and conditions of the offer that are signed by a prospective buyer. If it's in writing, they must present all of them. In multiple listing, a salesperson who negotiates a sale is directly responsible to
The seller.
This is tricky because here's what it is. It's either listing broker, employing broker, cooperating salesperson, the seller.
Employing broker.
broker. Oh, I'm sorry, the employing broker.
Given the information that you have here, the answer is B, employing broker. If there was more information given, here's the thing: I would still argue that they are responsible to their employing broker because they're acting as a representative of them, right? You always have to remember you're a representative of your broker. Okay? So the answer is C. B, his employing broker. A contract made for illegal purposes is valid, void, unilateral, or voidable. Void, dead upon arrival. Do not pass go. A salesperson who has completed a sale would ordinarily receive his or her commission from the seller, seller, and buyer with their permission, or none of the above. None of the above. They would receive it from their broker. A joint tenant may not sell his interest, give away his interest, encumber his interest, or sell the property. Sell the property. Excuse me. They can give away, they can encumber their interest because it's ownership. They own it, right? They can sell their interest. They cannot sell the property. Okay, so they would need consent of the other party. There would have to be an agreement with.
But not in tenancy in common. You don't need consent to sell it.
Unless you have full ownership.
Like if you have a tenancy in common situation, can you sell your portion of the?
Yes, but you still would not be able to sell the property.
But can you sell your share?
Sure, which is answer A, right?
Okay.
You could sell your interest, yes.
Yeah.
So even in a tenancy in common, you can still sell your interest, give away your interest, encumber your interest, but you cannot sell the property. You see what I'm saying?
Yeah.
So if a broker acts as a dual agent without disclosure, which of the following may occur? Loss of license, rescission of contract, forfeiture of commission, D, all the above. D, all the above, because it is illegal. You cannot have dual agency without disclosure and consent. That's a key thing. An owner who wants to employ more than one broker should give each broker what? An open listing, the floozy listing, the one where there is one seller, multiple brokers, right? The withdrawal of an offer before acceptance is called rescission, revocation, reversion, or rejection.
A.
It's a revocation. I would kind of give you, this is a tough one.
Rescission sounds
Isn't
like you're
revocation
rescinding.
revoke?
Yeah, you're revoking the offer. I'm extending it and I'm revoking it.
I would think rescind the offer.
Yeah,
similar.
rescind is. a better word.
Again, that's why I'm saying it's like I would like
That's a phrase.
A, yes, like A, I would take A in certain situations.
What will the state
PSI.
The PSI might give you something different.
They're
However,
gonna take a lot of money.
Yeah.
oh, listen. PSI. I hope someone from PSI watches my videos because PSI is a pirate ship and they take your money. They made this test. I actually think it like they're making a boatload of money making this test harder. So, but I digress. Upon the completion of the sale of a mortgage property, the seller must pay off the mortgage, deliver the deed to the grantee, record the satisfaction of the mortgage, and inform the Department of Banking. This is a tough one.
On completion of sale. Seller must.
So the property's mortgaged, right? Right?
Yeah, the mortgage first.
Do you?
Yeah, you have to pay what you owe.
Are there ever a scenario that you can think of that wouldn't be the case?
If you don't owe mortgage.
No, it's mortgaged, so it's a mortgage property. So let's think about the scenario that. So you ready? Let me give you an example. Remember when we talked about VA loans?
Yeah.
What did I tell you about VA loans?
They guarantee a mortgage.
Sure, the VA guarantees a mortgage. Great, fantastic, as opposed to the FHA insuring it. Yes. But what else did I tell you about the VA? I said that those loans are assumable, right?
Yes.
Ah. So you want to change your answer? So maybe B?
Yeah.
Yeah. You see? Yeah, tricky, right? B is the answer. The only obligation of a mortgage property, the seller must deliver the deed, because there are examples where a mortgage can be assumed. Again, not all the time, not 100% of the time, but there are definitely times that, because here's the thing, you ready? If it was A, it would have to be C as well. Do you see?
Yeah.
Or if it was C, it would have to be A as well. So you could cross off D, but what happens is you would struggle with C and A, and what happens is you would spend a lot of time trying to figure out which one it is, and you would just pick one. Whereas the one that's really the answer is B. So you have to read what it's asking you, right? A salesperson may advertise a property for sale only if he or she personally listed the property, if the name of his or her broker is included in the ad, if his broker is entitled to use the term realtor, if he or she pays for the ad himself out of his or her commission.
B.
B, if the broker's name is in the ad. Okay? The company name has to be in the ad. Broker has to be in the ad. They have to be larger than the salesperson, than the name of the salespersons. All right? Accrued depreciation may be defined as future depreciation, the total depreciation from the time of construction to the date the appraisal occurs. Deferred maintenance, or D, none of the above. It's a total depreciation from the time of construction date to the appraisal from all causes. So accrued, when you accrue something, it's basically built up. Accrued depreciation. So it's not something that is future, right? Because if it's accrued,
It's already happened.
it's already happened, right? If I am accruing, if I have a little pile of dirt and every week I put a little more dirt on my pile, I'm accruing a dirt mountain, and my accrued dirt mountain is what is here. My future dirt mountain, is something I actually, how I refer to it as accrued. When I'm thinking of accruing things, I think of what my laundry basket looks like, because me and my wife, we do separate laundry, and my laundry basket looks like Mount Vesuvius. Like I literally, and then what happens is I do the sniff test. So I'll go in there and I'll like pull things out from like the middle, and I'll be like, I'm like, are we good enough to go out today with this? And there's some times where I'm sitting there, I'm like, oh, look, and then she says, why don't you just do laundry? I'm like, look, I'm gonna put this on YouTube. I don't care about anything anymore. She's like, why don't you do laundry? And I'm like, no, that takes too much time. And then like the dog and the cats, and then I always have a reason why. However, I digress. Regarding a dispute between licensees concerning the division of commissions, which the following is correct? The Real Estate Commission can demand an accounting. The Real Estate Commission is responsible for settling disputes between licensees. The salesperson cannot sue his or her broker for commission if he or she feels they have not been paid. D, only broker can file a complaint with the Real Estate Commission. What is the answer?
D.
A. Sure. Why? Real Estate Commission is not responsible for settling disputes because I told you they govern between the public and licensees. Salesperson can sue his or her broker for the commission. That has nothing to do with the division of commissions, right? The whatchamacallit, the real answer is A. The Real Estate Commission can demand an accounting explanation. An exclusive agency contract is only terminated if the property is sold, must be in writing, can be listed by the owner with more than one broker, does not require a termination date.
Hey,
Not C.
How about B? Exclusive agency contracts. Exclusive. Anytime you get into exclusivity, it cannot be oral anymore.
oh,
Right? Exclusives must be in writing. Okay? A listing agreement in which the owner promises to pay a commission under all circumstances of the sale, except if he or she sells the property him or herself, is exclusive right to sell, exclusive agency, a net listing, or sole and exclusive listing.
Exclusive agency.
Exclusive agency, bam, bam, boogie. Exclusive right to sell is when they owe a commission under all circumstances. Exclusive agency, they still reserve the right to sell the property on his or her own without paying a commission. A residential referral agency must include which of the following in their contract to a prospective tenant: the date and duration of the contract, the refund policy, a statement that the business is licensed in the New Jersey Real Estate Commission, or all the above? All the above. Rental referral agency must include all of those things. All of those things. 93. The gross rent multiplier. The use of the gross multiplier to assist appraising real estate property leased to various tenants is based on gross income in relation to the capitalized value. B, relationships between value and sales price of the property. C, gross income and anticipated income. Or D, schedule for gross income and expected net income.
No idea.
The gross multiplier is B. The gross multiplier, remember we told you that it is whatchamacallit, the income divided by the value.
Oh, yeah.
Income divided by known value gives you a gross multiplier, right? It examines the relationship between value and sales price. And then what happens is you can extrapolate that and get the value of a property and unknown of the subject property if you only know the income. We're almost through this. We're page 10 of 11. So we're hitting the stride. All but which of the following are fiduciaries? Principal, trustee, guardian, receiver.
D. Receive.
This is an awful question. It's A. This is an awful question. That was one of my ones that I worded that's so awful. I hate that question. I always want to take it out, but I never do. Money's paid out by the guarantee fund in New Jersey in the event of a seller suffers a monetary loss due to embezzlement of the money by a licensed broker, a licensed real estate salesperson, or an unlicensed employee of a real estate broker. B, salesperson does not get paid his or her broker in accordance with the written agreement. C, an aggrieved party did not sue. Or D, a co-broker did not honor his or her agreement.
Hey,
A.
A, absolutely. That is the answer. Which of the following is not an example of physical deterioration? Poor floor plan, peeling paint, cracked patio, missing shingles.
A.
Yep, that's functional obsolescence, right? The boundary of your property can be changed by accretion, amortization, avulsion, acceleration.
Accretion.
Right, because that's the creation of new property through the deposit of what?
alluvian.
Alluvian, right. Haha.
What's alluvian again?
Alluvian is like sediment. It's like
Stuff.
miscellaneous stuff. Because what happens is when we're talking about it's the opposite. So accretion is the opposite of erosion. So when we're talking about the opposite of erosion, we're talking about accretion, which is the creation of property through the deposit of alluvian. We have to identify the sediment as stuff, right?
Yeah.
So because what happens is depending on where you are in the country, where you are even in the state, if you're down south in like Cape May, there's a beach that basically is all glass, okay? It's basically all glass pebbles and everything. So what happens is we wouldn't be able to say that's sand because that's an inaccurate description of that. It's alluvian. And when we look at sand, we say that's alluvian. A contract, the terms of which have not fully been performed, is known as
Executory.
executory contract. In a typical real estate transaction, the buyer's agent is the listing broker, participating broker, the listing and the selling broker, neither broker.
Neither.
The buyer's agent is technically the participating broker. It's worded really wonky because if you told me neither, I would be fine with that because the buyer's agent, the agent itself is not a broker. So you're correctly identifying that. But they refer to it as the participating broker, and you have to realize the buyer's agent is working as a representative of. It's a poorly worded question, but it's B. In a typical real estate listing contract, the broker would best be described as a general agent, a special agent, principal for the agent, principal of the subagent.
Special.
Special agent, right. Most transactions, most real estate listing contracts, we are working as a special agent where all we are doing is marketing the home for that seller. Eminent domain, taxation, police power, and SG are,
Limitation on the ownership of any property.
they are limitations on the ownership of any property. They are not limited to federal government. They are not benefits accruing to the owner, and they are not limited to state government, right? In estimating the value lost by a structure due to physical deterioration, the appraiser places the greatest emphasis on the condition of the surrounding buildings, the zoning of the neighborhood, the original cost of the building, or the observed condition of the subject building. Yeah, D, right? If we're talking physical deterioration, what are we looking at, right? Under the Pinelands Protection Act of 1979, all of those statements are true. D. Now, this is it. This is all you have for me. We got several questions left, and then I have no more for you. I have educated you to the point that you are the most educated that you could be. You ready? Which of the following is not a remedy available to the parties when the contract is breached? Unilateral rescission. Breach of contract is basically when you fail to perform a contract.
Okay.
Remember we said that in the other one? Like way before, like 3 pages back. So when a contract is basically not performed, what is a remedy to all the parties? Unilateral rescission, court action for specific performance, sue for money damages of expenses, or file a criminal complaint. Well, no, if you fail to perform a contract, you could sue for money damages, reimbursement of expenses, right?
I thought that's what it's saying.
No.
Well, it says not,
Oh,
right? In big letters. Damn, Daniel, right? How about file a criminal complaint? If there's a breach of contract, what happens is you have suits, you have rescissions that you could do. However, it is not a criminal act to be in breach of a contract. Failure to perform a contract is not a crime, right? All but one of the following is used to estimate value: improvements, deterioration, livelihood, economic life. C, livelihood. It's one of the things that's not like the other. Sesame Street. Remedy in court which could compel a party to a valid contract to sign a deed is specific performance, foreclosure, execution, equity of redemption. The suit is actually called specific performance because that property is specific. I am asking you to perform the contract. It's actually in the name. The suit for specific performance is basically, again, stating there is no other property like that one, 123 Main Street in Freehold, New Jersey. Because of its specificity, you must perform. Prospective purchasers of a property, as evidence of good faith, frequently make a deposit called consideration, earnest money, collateral security, a deferred purchase money trust. It's called earnest money, right? An exclusive right to sell. The property owner can still sell the property his or her own without obligation to pay a fee, would pay a commission even if the property were not sold, is obligated to pay the listing broker a commission even if another broker finds a buyer, or D, can list the property with more than one broker.
C.
Well, exclusive. One. They can't list the property with more than one broker.
Oh, I thought it was saying couldn't do. Yeah.
That's why you got to read them. How about C? C. A broker may properly advertise free appraisal, free cooking gas, free parking, free market study. Free market study? Like you could do a free market study, right? You could say, hey, here's a free market analysis. It sounded good at this hour of the night. You're like, yeah, free parking sounds great. The provisions of building codes are designed to establish a minimum construction standards for buildings within the state, licensing requirements for contractors, fees for building permits or lot sizes. How about A? Building codes actually set construction standards for buildings within the state. Man, There's nothing else. There's no more.
Do you need to pass?